Acting Public Protector Advocate Kholeka Gcaleka says that she's concerned that only 2% of her office's remedial actions are actually being implemented. The Chapter 9 institution published 15 concluded investigations into complaints on various issues for the third quarter. The Acting Public Protector joins us now for more on this. Advocate, thank you so much for your time, and thank you for joining us this morning. Well, an implementation rate of 2%, I think we can both agree, is well below acceptable standards. In your observation, what really is at the heart of this problem?
Good morning to you and good morning to the viewers, and compliments of the new year. I think at the heart of this problem really is the lack of the will to implement governance reforms and to reform maladministration within the state affairs, which also has been increased by not a good cooperation between the Office of the Public Protector as well as the executive and government.
Right. What capacity, Advocate, does your office have when it comes to enforcement? The last time questions were raised around whether or not remedial action that flows from the Office of the Public Protector is legally binding, the last time we had to answer that question, it ended up all the way at the Constitutional Court. Not every one of your investigations, however, can reasonably expect to be taken through a similar process. What other options do you have when it comes to enforcing some of these remedial actions?
I mean, the implication of the judgment regarding the binding effect of the remedial action, it means each and every remedial action taken by the Public Protector since that judgment has a binding effect unless it is reviewed by a court of law or there's an interdict in order for the party not to implement the remedial action. Well, we do have a unit that deals with the enforcement of remedial action. Yes, it is not as capacitated as we would hope for it to be. However, it should be a natural course that the remedial action is being implemented. Institutions such as ours, a constitutional institution, has been established precisely to ensure that it redresses any malfeasance and injustices within the state affairs. However, we are in a process of amending the Public Protector Act because the Public Protector Act actually precedes the final constitution of the Republic. Therefore, our jurisprudence has developed immensely since through court judgments, and it calls for the amendment of the Public Protector Act. And within the Public Protector Act, we are looking into adding a clause that brings into life the binding effect as per the court judgment, which would in fact have the same effect as our subpoena, where there is no implementation. It will result into contempt, which would then result in us following the criminal route rather than the expensive civil route, which we can follow currently in the instance, and we do not do it because it is quite costly.
I am curious, Advocate, how this lack of implementation hurts your work. I mean, I think at the very least, it erodes the public's confidence in the ability of the office to actually tackle issues of maladministration. At the very worst, take us through how you think this hurts your work.
Well, it doesn't erode the public confidence in the Office of the Public Protector. The public continues to file complaints with us and we follow up with them. And remember, not every complaint results in a formal report. The Office of the Public Protector is an ombudsman. We've got a high percentage of the matters that we take on through alternative dispute resolutions, which are actually implemented upon a settlement agreement.
Right. Well, you recently obviously released the results of the 15 concluded investigations in your third quarter. One of the high-profile investigations that your office, of course, is looking into is the Phala saga. What can you tell us about that? How far along are you in terms of completing your work?
Well, the case is at an advanced stage. We are at a drafting stage at this moment of the report. It is, however, not the final report. It is the report we issue in instances where we are not making any adverse findings. We call it a discretionary notice, which gives parties an opportunity to respond. And in an instance where we are making adverse findings, it is called the Section 79 report, which gives the respondent an opportunity to respond to the adverse findings that we would have made. So that's the stage at which the report is. And thereafter, of course, parties will have to respond, affected parties will have to respond to the report, and having considered their responses, will then have to draft a final report.
Right. Now, your office has consistently said that it would not in any way succumb or capitulate to any sort of pressure in terms of expediting this particular investigation. We know that this sort of investigation, one that deals with issues around good governance and integrity, can take up to 2 to 3 years. What do you say to those South Africans who are lamenting how long it's taking, particularly because this is a matter of public interest? It has to do with justice, accountability, and the rule of law in South Africa.
Well, acting in the interest of the public, acting in the interest of justice, upholding the rule of law actually means that we have to act independently, impartially, without any fear and favor. But most importantly, we have to follow due process. There has to be fairness in the investigations that we are doing. We have to conduct a thorough investigation that is in line with the merits of the matter and the application of the legal prescripts to that matter, which then means that we have to ensure that there's reasonable time that we take into the matter. But yes, considering that it is a matter that involves the president of the country, we have accordingly increased the resources in the matter. I mean, we've got more than one investigator. We've increased our quality assurance processes, which is critical because it is a kind of matter where the Office of the Public Protector cannot afford to have a criticism that it was reckless in its investigations or in any other form like the courts have done previously. That too is in the interest of the public.
Well, you've already accounted for us, the factors involved. Just how complex an investigation is the one like a Phala.
It is complex. It's an investigation, firstly, that's been investigated by multiple institutions, and it is an investigation, obviously, involving EMEA. We are investigating in terms of the Executive Members Ethics Act, we are investigating in terms of the Public Protector Act, and it has its complexities. However, it is really not an investigation that will take 2 to 3 years. And as I've already said, we've made quite strides in this investigation. It's just over 6 months, It's not even 7 months as yet, and we're already at the drafting stage of the initial report. So we have made quite progress.
All right. Well, Advocate, we'll leave it there for now. Thank you so much for coming onto our program and, of course, taking us through your various investigations and updating us on the progress being made into the investigations into Phala. That, of course, being acting public protector in the office of the Public Protector, Advocate Kholeka Gcaleka.